Hello, Gabriela. Thanks for being with us.
Hello, Teresa, and thanks for having me.
So we would like to talk about automated decision making, which was kind of the subject of one of the reports that your organization has published recently. So my first question would be, what is automated decision making, and why is it considered to be a threat to individual rights or fundamental rights?
That's a great question, and this is primarily because we don't really have a definition of it. But we can see it when we see it, and we know, we know when we see it. I can give you a couple of examples. So, under the big umbrella of automated decision making, we can have, for example, an AI system that draws conclusions about callers who call a bank, and they are recorded, their voice is recorded, an AI system is deployed on the recording of their voice, and pretends to decide or decides, allegedly decides, which caller is more angry than the other. And then it ranks the callers, and the workers at the bank call with priority the angriest clients. And I'm not giving you just a random example. This is an actual case that was decided by the Hungarian Data Protection Authority very recently, at the beginning of this year. And that implied a form of automated decision making, which in the end was not found to literally fall under Article 22 of the GDPR, but that is an example. There are many other examples. In this day and age, usually any form of algorithms that are deployed on data sets built with the support of personal data, and that then result in some type of decision would be covered by this big umbrella of automated decision making. Now, we don't have precise case law to indicate exactly the decision part in this automated processing of personal data, and how it would be cataloged as a decision, but so we when we see it, we know it. Type of situation with automated decision making, and then the question of why this presents increased risks to the rights of individual. Well, that's a very, very big question, and this is probably deserving an entire PhD thesis, I would say. But
somebody
yes,
out there.
Somebody out there. Yes. But of course, when you have sometimes very, very important decisions about yourself that are taken automatically, applying mathematical formulas, and you feel at risk, right? That those decisions might not be fair, that you may not be evaluated fairly, and so on. And to give you an example, which probably could resonate for your colleagues, in 2020, the International Baccalaureate, which is this organization that organizes the International Baccalaureate examination, decided to give grades for the last exam of the graduate high school students on the basis of their performance throughout the program, but also on the basis of the average performance of their schools. And that was put into an algorithm, and it resulted into a grade that was assigned to each student, because they could not, in fact, take an exam in person. It was the first year of the pandemic. So, for example, this is a form of automated decision making, and a form of automated decision making that may be impaired by bias, because of course some students came from schools that maybe historically did not perform well, but maybe that student was actually exceptional. On another hand, maybe a student was not exceptional, but they afforded to go to a very good school that performed historically well. So you see, you cannot really describe perfectly the risk, but it's definitely there. So very windy answer, but unfortunately that's the nature of the question.
Yeah, that's where we are at the moment. Yeah, thank you. So in your report, you looked at how this Article 22 that prohibits solely automated decision making of the GDPR is applied across the EU. What were your most interesting findings? Like, what were your conclusions?
I have several, and it's true that we looked at Article 22. We were very curious whether it's actually being applied. There was a lot of criticism out there in the community saying that Article 22 is not really relied on and it's not that useful, right? And we wanted to see whether that's the case. So we went to look for decisions where Article 22 was invoked, and we looked at data protection authorities' decisions, and we looked at first instance courts, higher instance courts, the Court of Justice of the EU, and we were able to find a number of decisions that invoked Article 22. Some of them successfully invoked Article 22, where the cases clearly involved solely automated decision-making that had a significant impact on the individual, significant effect. Some of them did not involve solely automated decision-making. However, even in those cases, we found that the authorities and the courts applied the GDPR in any case, because Article 22 is just one of the provisions of the GDPR. And to the extent that this automated decision-making involved somehow personal data when algorithms were being built, or to the extent that this automated decision-making resulted in personal data, well, this amounts to processing of personal data, so the GDPR is applicable to that entire processing operation. So we ended up identifying about 70 cases and individual guidelines, individual decisions or opinions by data protection authorities, because it might also be the case that we found such a case in Denmark, for example, that one of the social benefits authorities asked the data protection authority whether their this automated decision-making that was deciding what benefit goes to whom, asked the DPA whether they can do that and in what circumstances. So the DPA issued individual guidelines for that particular situation. And so we discovered 70 cases, and we analyzed them quite in detail, and we collected all of that into this report, finding that, in fact, the GDPR quite effectively already tackles a lot of this new algorithmic world in which apparently we live now.
Okay, very interesting. And these 70 cases, in which fields? Where like health data, employment, education, I guess were spread all over them, or?
Indeed. So because this is the challenge, but also the beauty of data protection law, it actually touches on every single field. And this case that I mentioned with the International Baccalaureate is, for example, one of the cases that we found. We also, the bank case with the AI system that recognized emotions, that was another case. We looked at facial recognition being deployed in schools to tackle attendance. And that was found to be unlawful because it was considered to be disproportionate. Really, I can go on and on.
Yeah.
We found in every single sort of aspect of life a specific case. There are a couple of cases from Austria which are also interesting. I remember a case about someone that wanted to get a better deal with their phone subscription, but they couldn't get a better deal because they had a low credit score. So they exercised their right to know how that credit score came to be. And the company refused to give details about the logic involved on how the credit score, the credit worthiness of the person was assessed. And then that person actually went to the Data Protection Authority and challenged the fact that there's no transparency about their credit worthiness. And that came about because the person couldn't get a better deal for their phone subscription. Yeah. So from cases like this to cases like deciding your grades, that's it's everything is there.
Okay, yeah. Well, thank you very much for these insightful comments. We're really looking forward to see you around at the conference. Have a great conference, and
thank you so much for the opportunity to explain in such a lengthy manner all about automated decision making.
Our pleasure. Thank you very much. Bye.